Section 7, Remedies. Now, Section 7 of the contract covers what starts to happen when something in the contract goes crossways. Either party fails to perform in the manner that they were supposed to perform on. Now, most people think that means an immediate breach of contract, but in our contract that we use for purchases, there is a period here called a cure period. It comes out in Section 7, and it's the first paragraph, 7A. All right. And what a cure period is allows the offended party the opportunity to signal to the other party, hey, you are not performing the way you're supposed to perform. It's pretty much the nuclear option when things start going crossways and people start screaming at each other. It is a simple form. It's called a cure notice, and it's a heads up. You just send it to the other side and say, this is initiated by the buyer. Seller did not maintain utilities on until close of escrow. Right, which, as we noticed in the last section we were in, the sellers are obligated to do that because of the contract. They've signed on to that and stated, we will keep the utilities going on. So when somebody comes through for the 72-hour walkthrough and the utilities they can't do a full walkthrough, especially if there's things that were called out on the Binzer that the seller had agreed to fix. So what it is, you send this over, and then the receiving party, the person who's being cured against, has 3 days to perform. And at the end of those 3 days, once that time period has gone by, then it is actually considered a breach of contract, right? And this paragraph here really, really calls that out, all right? You're going to send it over. They got 3 days to fix the problem, right? At the end of that, you issue the cure notice. At that point, a seller can make a claim against the earnest money and cancel the contract, and a buyer can cancel the contract on that side and get out clean and get their earnest money back. So the cure notice works in the contract. Is just one of those. It's the final nice step. If one side or the other fails to cure the issue, whatever it is, then the other side, then the breach happens, and then we go into paragraph 7B. So the non-breaching party has the option to cancel the contract or proceed against the breaching party in any claim or remedy, that the non-breaching party may have in law or equity, subject to the alternative dispute resolution, and we're going to cover that in the next paragraph. All right. The seller has the option to take the earnest money as a fair approximate of any of the damages that they have. If they do, they wind up waiving the right to any, claiming against any further damages. So, remember that when you're on the seller's side. There's a couple things that are called out, all right? In the event of buyer's breach arising from the buyer's failure to deliver the notice required by Section 7B, we remember that one. That's the one about not going to be able to get the loan in time. Or the buyer's inability to obtain loan approval due to the waiver of the appraisal contingency pursuant. Seller shall exercise this option and accept the earnest money as seller's sole right to damages, right? So if they have waived the appraisal contingency, then they don't get it. So they don't have the option to go beyond the earnest money. All right. The other one on this is they call it sections 1D. If you remember, that's the one where we're discussing close of escrow date. All right, and we've both sides have stated we were going to do what needs to be done to make sure that we close at close of escrow. Buyer's going to be delivering a cashier's check. Seller's going to do what they need to do to get so the escrow can record the deed. So that's considered a breach. That's called out in here too. Going back. All right. So the Association of Realtors has created what's called an alternative dispute resolution. They go to arbitration if there is an issue, and especially if it's one of those issues where neither side can come to a conclusion on this. All right. By signing the contract, you are agreeing that you are going to use this alternative dispute resolution instead of going straight to court. There's some exclusions in the next paragraph, but on this one is they're going to get together. Both sides are going to pay for a neutral third party to arbitrate the situation. You sit down at a table, you have a conversation about what's going on with this. I'm a little vague when it comes to arbitration because I've never been in an arbitration, because I've never, none of my deals have ever gone this far into it. If for some reason that neither side is able to decide on which arbitrator they want to use, they can, the dispute can go to a neutral third party outside of real estate called the American Arbitration Association, and they have rules for the real estate industry, and that third party will come in and be the arbitrator in that. The decision of the arbitrator is final. It's non-appealable. Judgment assigned by the arbitrator can be entered into a court, and the court can then use that. Let's say you wanted to put a lien on the property on the buyer side, or let's say that money wasn't transferred, something didn't happen. You wanted to have that judgment sitting in there in the courts, later on. You can do that. Now, this all being said, the losing party still has the option to walk away from the arbitration within 30 days, but that opens them up to an actual court option. There's a couple things that are excluded in this thing. Small claim courts actions, anything that's going to be under $3,500, that can go into the small claims court, and you don't have to do arbitration on that. If for some reason it gets kicked out of small claims into a regular court, then you have to have the option to resolve it through arbitration. Any foreclosure issues, anything to proceed, force a deed of trust, mortgage, agreement for sale, that you'll see those things if there's a seller carryback involved, if the seller's got any kind of extra equity in the property and the buyer fails to perform after close of escrow. Right, that could be would be an exclusion from it. Filing an enforcement of any mechanics liens that might have happened, unlawful entry or detainer action, exclusion from media. You do not have to go to arbitration if the seller never left the house after close of escrow. All right, this can go straight to court on these things, to get them removed. Then the final paragraph on this is attorney's fees and costs. All right, and ultimately on this thing is that you are agreeing, no matter what side you want, is that the loser is going to pay fair attorney fees and costs to the winning side. All right, and it's eliminated out in here. Attorney fees, expert witness fees, fees paid to investigators, and arbitration costs. So if there was something that came up, both sides go to court. Let's say the buyer had to come in there and bring in not just an attorney, but like an actual electrician, pay the electrician X amount of money to be a professional witness to come in and say, no, this was not resolved in a workmanlike manner. Remember that term that we used earlier. All right. Then the buyer at that point could be awarded, the cost of bringing in that expert. So this covers Section 70, this one, or Section 7. This one is a really short one. I could tell war stories and whatnot, but let's keep this one short. We're going to go into additional terms and conditions, and why this big blank page you're going to be seeing is where realtors get sued and E&O insurance winds up making payouts. And then at the end of it, we're also going to cover, Section 9 down here, because that one's really short. So those two are going to be one episode, and we'll be covering that next week. And this will wrap up the entire purchase contract classes. Thank you.